So, good morning, everybody. I'm sorry I don't speak your language, so I try to do it in as best as I can in English for you, and try to start with IP today. So, introduction to IP. There are three topics. Introduction to IP. What is a patent? What is a trademark? And the second part is how to manage IP in your everyday business, in your organization, in your company. Better with you?
Mēs labāk uzliksim, jā?
Okay. It's quite great to have such a lot of people over here, so it's not that often that the IPR help desk has so much people listening. Yes, and part 3 will be about what to do if someone else is infringing, for example, my patents or my trademarks, how to enforce my rights. And of course, how to exploit my rights. Because before I start to discuss what is a patent, what does it cost, what is a trademark, and so on, it's a question, why to spend all that money for this? Today we have economic crisis all over Europe, so people have to think about other things, how to earn the money and how to keep the money together in the companies and how to make the business. But patents, this is a part to make money. And everybody of you, independent where you are working or working as a researcher or working in business, you create knowledge in any kind. It's very often it's protectable via any kind of a registration at an office, sometimes not, but it's all kind of knowledge you create, and you have paid for it. You put your effort in it, you put your time and money in it to create new products, new processes, whatever. And it's important to protect them. And only if you have protected them, you can just enforce them and tell someone else not to use it without pay something for it. No? So it's a possibility to make money finally. No? So yes, my name is Sabine Albrecht, and I'm working for the European IPR Help Desk. The European IPR Help Desk is a European funded project. So we have some partners, and our task is to give more the knowledge, to spread the knowledge. I think it's quite a bit louder, isn't it? Huh? It's okay? Good. To spread the knowledge about IP all over Europe, more or less. And yeah, my background, I'm a natural scientist from my background, so I studied biology and agriculture and made a PhD in plant breeding and worked for more than 10-15 years in the plant breeding business and as well at a chemicals company in Germany, mainly in the patent office for all kind of inventions from the area of biotechnology and so on. And for more than a year now, I'm working for the IPR Help Desk, and the company which is a partner is Euris, and we are located in Saarbrücken, which is in the southwest of Germany, quite next to the French border. So these are the topics of today. I will start with what is a patent, what is a trademark, and then we come how to find out more about patents. What are the others doing? Because no one is alone in the world, and there are a lot of people as well, other business, other research organizations who are working in a comparable field. How to find out who else is in this field, and that's are the main topics for the first part, and the enforcement will will follow. So, what does it mean, intellectual property? So, once a colleague asked me for a long time, intellectual property, what does it mean? Any kind of castles built in the air or something like this? And no, it's not like this, but it's something in your head first. So usually in an organization, university, research organization or company, you have a lot of business assets. You have things you can touch, these are the tangible ones, your machines, your buildings, your desks, whatever, and you have all the things which are in the head of the people who are working there, and that's what we call the intangible assets and the know-how, and by that the intellectual property. And for this, for the intellectual property, there are a number of ways to protect it. So at all we have 3 groups, let's say it like this, of intellectual property. The first one is everything which can be protected via registration or via an examination process. Though this is the so-called industrial property, so patents and trademarks and designs mainly. It means that there is an office where you can go, where you can have it registered, examined, and so on, and finally you get a notice, a legal notice that you have the right for that. Then we have everything which is not to be registered, but of course it can be protected. So this is what we call the copyright. All kind of artistic and literary works like books, pieces of music, pieces of art, theater, as well as software and databases, they are protected via copyright. And the group number 3 is all what we call the so-called so-called soft IP. All the things, the knowledge you have, but what you are not going to make it public in any way. You keep it secret, yes, more or less forever, or how long you want to have it secret, like contracts with employees or contracts with business partners, and as well kind of business secrets. So I suppose everybody of you knows the most well-known business secret. It's the recipe of Coca-Cola. So it's still covered. And they never made it public. There are a lot of people who try to copy it or to get it in a comparable way, but it is still made secret. And this is quite fascinating because this is for 150 years now, and there must be a great internal management that there will be no leak. Nobody will tell it to the neighbor in the evening having a beer. And so I can tell you what I was doing today. So they still keep it secret. Yes, let's start with the copyright. This is something which exists automatically when it is created. Thank you. You don't have to put the C on it, but it's a bit better. But even if it's not registered, you have to take care of the copyright of others. And maybe you know that Germany lost his Ministry of Defense last year, and he lost his PhD as well. So this both happens because for his PhD work, he copied a lot of things from others, which is not forbidden, but unfortunately he forgot to sign it and to show from which book he copied it, and by that was the end of his academic career and the end of being the German Ministry of Defense. So we have some more of these politicians, but this was a very exciting example. But so you have to take care of the copyright of others, of course, which is not easy and which gives a lot of struggle as well. And pieces of music are copied and put into another surrounding, so there's a lot of court action as well. Yes, protection 70 years after the death of the creator. Then we come to the patent. What is a patent? In the beginning, it's a piece of paper. Finally, it's a legal title. You get a title from the office, and that you are the owner of a certain right, and though you are enabled to forbid others to use your invention without your allowance. And So it's up to you what to do with it, to use it for production or production of a process or of a product, and usually it's connected with a geographical scope. You decide in which countries you want to have your patent valid. We come to the steps a bit later. So, but important is that it's always connected with a technical invention. So you get a patent only for a technical development, a technical process, or a technical, by that technical produced product. And some things are quite important, so you don't get it for everything. So something has to be new. It should not be known until that time you file it at the office to the public. This is quite important for people working as researchers in universities or research organizations, because they would like to get it and have any kind of publications and go to seminars and conferences. So as soon as your new idea and how it is to be proceeded is getting public, even in a conference book or on the internet as well, then it's not new anymore. Not new in the sense of the patent law. No. So if you're working in a project with a number of partners and all the researchers should take care of these aspects and discuss it with the other partners first. I know that I was working in research for a couple of years myself, and I know researchers like to talk too much. This is very often a problem. And yes, it has to be inventive. It should not be obvious. So that is a new step, for example, not obvious to find. And the third one is mainly the industrial use. For example, you are inventing a pair of trousers with 3 legs. I suppose it must be novel, and I think it's inventive as well, but where is the use of it? No. So everybody say, nice, a pair of trousers with 3 legs, but who shall wear it? No. So you won't get a patent for a pair of trousers with 3 legs. There are some exemptions in Europe. We're always talking about the European, because we are in Europe, so the European law. So you don't get a patent for just an idea of how to do a business or any kind of a method. It must be always a technical step involved. Then software, no patents on software in Europe. Only one exemption if it's directly connected with a technical process. For example, if you have an X-ray machine and the program as well has always a correlation between the X-raying and maybe how thick the body is who will be X-rayed. No? And depending on the thickness of the body, the X-rays will get stronger or less strong, whatever. And with such a direct interaction, then it is possible to get a patent for the software as well. Yes, all kind of business methods, medical therapies, plant varieties, animal varieties, no patents in Europe for that. In the US, it is a bit different, but not in Europe. Yes, 20 years. 20 years at the time of protection. After 20 years, everybody can copy it without needing a license. Some exemptions just in pharmaceuticals and sometimes in the plant protection materials. So they get 5 years extra quite often because it takes such a long time to develop a new pharmaceutical. But 20 years is the normal duration, and after that it's done. That's how it looks like. I suppose a lot of people of you have already seen it. This is a European patent application. The EP for Europe, the sign of the European Patent Office, and yeah, we have some bibliographical data, which means the date of the application, the name of the inventor, the applicant, which is mostly a company, and title and abstract. And that's what you get out of it. So, as I said, you get the name of the inventor, the owner, and abstract with a short description of what it is about. They have the description in detail. There's always a part with what is already known in the world about this topic and what is what I did new. What is the difference from my invention compared to that, what is already new, and what is the positive aspect, how to improve a process, to make it better, to make it easier, to make it cheaper, whatever. So all this is connected. And then they have the claims and very often the drawings, which make it a bit easier to understand and explain the invention. To apply for, there are 3 ways. You go national to your national patent office, you go European at the European office, or you go international. This always depends on your invention. It's a business decision. So where are your business areas? Where might be the interesting markets to sell the product, for example. So this is always a thing to discuss because it's always money involved for this. And yes, geographical scope. Usually, what I said, you go national and you leave it national. If you say, okay, my market is only in Latvia, for example, then I stay here. So I don't need to spend the money for a number of foreign countries. Or you say, I'm not sure, maybe my business will develop the next years, and so it's better to think about this earlier. Maybe this and this and this, maybe 5 additional European countries. I should take this into account as well and broaden it, because there are always time limits involved, and when you have to decide. As you can't decide whenever you want. The law gives you some time limits, and this has to be kept in mind. And for Europe it's easy because you have it all in one hand. If you go to the European Patent Office, they do the examination and they grant the patent, and so it's all in one hand. It's a national as well. For the international way, there's just one way to apply for the patent, and the examination will be done in each country. This is how long it takes. So very important, day 0, or let's call it day 1, the application date, because from that, all kind of further data and actions which are connected with date or time limits count. They count from that date. So you apply for a patent, it means you have written everything down and send it to the patent office. You get a stamp and a date and a number. That's very important. And you have to pay the fees. Nothing goes without paying fees. Now, very, very important. And it's not known to the surrounding at once. So if you send it to the office, it will be covered for 18 months, 1.5 years. For this first part, on 1.5 years, it's kept secret. Nobody will know that you have applied for a patent. And this is quite helpful because in the meantime, you get a search report. So the examiner goes through your application, takes some keywords, puts it in his database, and in the end there comes maybe a list of documents which are connected with the area you are working in. And then it's important to take the time and to read it very carefully, because sometimes the examiner is wrong. So this is quite far away. There's some same words used, but it's a complete different area. Then you can just put it away. But sometimes they found some journals you didn't even think about, that there might be someone else to work in this area. So it's important to read it carefully. And in case it's getting too dangerous, you can decide to withdraw the application. Just to take, okay, I'm sorry, I was wrong. I thought I was the only one in the world to do this, and then you find out by the search report, unfortunately, I was not the only one in the world to work in this area, and then you can decide just to skip it, and nobody will know it. No. So it is as it hasn't existed any. And yes, that's it. But usually if you go further on, you have some discussions. They're going letters forward and backwards between the office and you. And after a while, the patent will be granted. Usually it takes between 4 and 5 years. It depends a bit on the area. So in the first years of biotechnology, it took 10 years. I know of one application that was granted after 20 years. So, but this was an exemption. But usually 4 to 5 years, then it's granted. But important is this as well, because after the grant of the patent, you can be happy. That's because very important step is done, but there's still an opposition period. Other people get children in this 9 months, and though you have time or you to think about, everybody can, yes, oppose your patent for what reason ever. They have to, of course, not only I oppose the patent, you have to write a reason and explain it why, but this is an important part, and this might take 9 months for everybody to oppose the patent, but this will be discussed, examined, maybe at the patent court as well, and this might take some further months till it is really finished, the procedure is finished. But this is how it takes. But for example, if you say, okay, what shall I do? I have a new product, I have done everything right. I have applied for a patent. Can I go for a license? Can I sell it or sell a license on my product? Or do I have to wait till all this is over, which is 4, 5, 6 years probably? No, you don't have to wait. You can start after day 1. On day 2, you might start to go into the public. You might start and find someone else, someone who is interested to buy a license, and so on and so on. It's always important to have applied for it, to have the stamp and the date from the office. That is the important thing. And so then you have done the first step for protection. But for any kind of business works and licensing, you don't need to wait till the end of all the procedures, because this might take years, additional years up here, and I'm always depending. Yes, the PCT, I said this is for if you go international, and this is a kind of, yes, called Patent Cooperation Treaty. 146 countries are now member of the PCT, which means you just need, for all these countries, you just need one form, one sheet of paper to be filled out, and then you have some time limits to decide which countries are important for me, but it makes it very easy for the applicant if you don't have to decide at the very first day which countries are important, so you have some months, 1 or 2 years time to decide and to discuss and to see how does the markets develop, whatever, but it's quite very applicants friendly. No. Yes, the costs. Usually it looks like this. No? That the money is just hoovered out, and a lot of money will you need for the translations. So there are some changes in the patent law, hopefully in the European patent law, and but at the moment, most of the money will be taken by translations and by the patent attorneys, unfortunately. This is an example from the European Patent Office, what it costs, the filing, the search, the examination. And if you want to know in detail what is important, just go to the home page of the European Patent Office, and then you can see in detail what kind of fees are important. And if you say, okay, this is so expensive, why shall I do it? But you see, all the trouble is fightings between Apple and Samsung for the rights in of the patents. So it's an important factor for economy. So you make money out of it, and so like Apple and Samsung make money out of their inventions, and though they try to be the only one to have the right and the first right for a certain invention. And you can only defend your rights if they are protected. You can try and defend it as well if you didn't protect it, but it makes it much, much more difficult to show that you have been the first one. So, and if you have applied at the office, you can always show this is the date, this is what I received from the office, the date and the number, and I'm on the safe side. Are there any questions from your side? But we have still time at the end, so don't worry. So I think they already said it, that the slides will be on the homepage, I think. So don't worry. Is there any questions? Trademarks. This is a trademark. I suppose everybody of you knows what a trademark is, and it's a sign to. Yeah, a combination of a sign, of a drawing, and some letters, whatever, to describe a service or a business. And so you can distinguish, for example, your business from another one's by a certain sign. A lot of things can be protected as a trademark. This is a combination of signs and letters, but you can as well have it shapes. Smells, perfumes can be protected, sounds as well, the jingles from telephones. This is all be protected by the trademark. So these are the examples. And what is the important thing of the trademark is, you can say, okay, I read IKEA, okay, 4 letters, okay, in yellow, okay. But I'm sure that most of you, if you read IKEA, you have the feeling you are standing in the store, because nearly everybody has been at least once at IKEA to buy something, and so you have the whole business in your mind. You do not only read the letters. And same holds true if you read, yes, Mercedes, or you have the car and you connect a certain image with it, and this is what it makes important, and this is what it makes the trademarks that expensive. Yes, the bottle, Coca-Cola, and can be protected as well as design, but as well as a trademark nowadays. And there was some examination, I think, a couple of years ago, that they threw some of these bottles at any beach, somewhere in Africa or whatever. And the bottles, no name on it, just a little red piece of paper around, but nothing written on it, no Coca-Cola, nothing. And at least of 50 meters distance, if you just put it in the air, that this is a Coca-Cola bottle. So it's how to recognize something is so deep in the mind of most of the people that even without having written the name, people recognize it as a part of Coca-Cola. And this makes the brand so valuable. Yes, 10 years in the beginning, but you can renew it. You can renew it as long as you are able to pay, as long as you want to pay, or your children and grandchildren want to pay, whatever. So there is no limit, no final limit compared to the patents. Yes, that's about it. That is what a brand makes expensive. So, for example, you have the apple. You don't only see the apple, but you connect it with the ideas of innovation. You think about Steve Jobs, a certain design, and so on. And so it gives quite a picture of a company, and have this function, have this function to really notice a certain brand, a company, or a business. Yes, as well the prestige depends on the car, for example. If you buy a luxurious car and drive it, or if you buy a cheap car, those take you from place A to place B. But it's in a lot of cases the image is connected, and same holds true with what kind of PC you are having, what kind of phone you are having, and so on. So you connect, but it's not only the image, but sometimes, very often, it's connected with a kind of yes, security. If I have a certain luxurious car, it gives me more security because maybe it's done better compared to a cheap one. So this is a bundle of reasons why we choose to buy yes, a certain piece of dress, a certain piece of furniture, car, whatever. Yes, and I think this is from last year, yeah. And so once a year, the brands are kind of estimated the value of the brands, and yeah. And that last year it was this Coca-Cola or Google in the very beginning. It depends a bit on the way how to measure it. It's a mixture of the value of the shares of a company and what they are selling, how much they are selling, and kind of people being asked of the if they know this brand or not. And out of this mixture, you get this estimation, like, yes, in the beginning here, Coca-Cola, IBM, Microsoft, and Google, and but it's always nearly more or less the same 10 being on top. So, and yes, yeah, come back if you just file for a trademark. So this is everyday basic. If you file for a trademark at the OHIM, it is the Office for the Harmonization of the Internal Market. This is a European Trademark Office, so which is in Alicante, Spain, and this is the filing fees, and so details you can find as well on the homepage of the OHIM, and it's worth to think about it, especially for those of you who are going to work in maybe a European funded project. So where you have project partners and you have a project name, an acronym, and so it is quite important to think about the project names in the very beginning, and if you just may keep it for a long time till you have a product and give this name to a product. Then we have the science finally. Yes?
Can I ask one question?
Yes, of course.
Can you tell us what is the practice of these trademarks which are very well known and they are not registered in local country, maybe in Latvia, as it is a problem maybe for us, because you can't register the trademarks in all countries, like I don't know, Adidas. It's not registered in all countries in the world. Can I copy this trademark if it is not registered in Latvia?
Yes, anyway. The question was, what about the registration of trademarks and how to protect?
Well-known trademarks.
Excuse me?
Well-known.
Well-known trademarks?
Like Adidas. We have a market where we can buy Adidas and it costs approximately 5 or 10 lakhs. Very cheap. But it is Adidas.
This is, yes, but this is the point of I know what you mean, of enforcement of rights. This is a kind of copying. Of course, Adidas is not very amused that you can buy in certain Asian countries a pair of Adidas or sport Nikes for, yes, €5, and usually in the stores it's around 50, 60, 70 euros or even more. No? This is a matter of copying. I'm sure they do not, those who sell Adidas for €5, they don't have bought a license, I'm sure. No? So, and this is a kind of black market which Adidas or other trademark owners try to eliminate, no? But it's difficult. No? So this is.
But I think the question is, when you register a trademark, it's also by country, or you register it once in Latvia, for example, and then
it's up to you. It's your decision. If you decided to register it national, like only in Latvia, then everybody can copy it in another country. You don't have to have a force to go against it, or if you go it worldwide. No? It depends what you want to pay.
Legally, then it's not infringement. I mean, like if IKEA is not registered here, then I can open
Yes,
holiday.
in the first way, but I'm sure even the big brands, they have the registration all over the world. And even after a certain time, if it's getting so well known that even if they have forgotten a certain country, or a smaller country, whatever, it's a kind of, how do you call it in English, of use for the long term. So even if it's not registered in a certain country, but it's so much well known that it knows that IKEA is always a brand, a Swedish brand from the Swedish furniture house. So, of course, it's difficult for a small company just beginning, just starting on the market. No, so they will have to really to decide which countries are important. Where do I register my trademark? No, but sometimes it's much more important to register a trademark than go for a patent. So if you have to decide, thus it's a limited budget of money. Sometimes it can say, okay, can I go for a trademark or a patent? I can't afford both. No. But sometimes it's more important to go for the trademark first to cover the business. Yes, design. Here, only the individual character and the novelty is important. So if you come back to the trousers with the 3 legs, so you won't get a patent for trousers with 3 legs, but you might get it registered as a design. So because the use is not needed for a design. It just has to be new and has to be as individual. Or like this bicycle. I do not know how good it is to run this bicycle, but you can just protect the shape and the colors and the way it is. So it's an individual design and it looks new compared to others, maybe. And then you might get a design registration. Yes, 25 years, it's protected. After that, you can copy it. Yes, you have products with a number of rights in it. So here we have the Nokia, quite a bit. Not only this is old-fashioned, but already this appears to be old-fashioned to the one which are on the market now. So any idea what rights are in such a phone, such a mobile phone?
50 at least.
Pardon?
At least 50.
Yeah, and which ones? 50 is quite, yeah.
Camera and a lot of things.
Yeah, right, and that's exactly our point. So you have to design first for the shapes, for the shape of the camera, and I think this ones they didn't have the camera, so so yeah, they have a trademark for the name and for the jingle, for the sound. Yeah, the trademark. And yeah, copyright for everything which is not connected with the technical steps, the software for the jingle maybe, images. And yes, the patents for all the technology inside, and data, and yeah. And as well, a lot of things were just kept secret in the very beginning, just to use it maybe for further developments, new products, new telephones. So in the very beginning, it was up to 50 rights. Nowadays, it's between 500 and 1,000 at least in such a small phone. And you see it on the trouble, and there's the struggles between Samsung and Apple. They spend a fortune for these court actions, and most of the money goes to the American patent attorneys. So sometimes it appears to me to be a method to print your money by your own, being an American patent attorney. But yes, so this makes it important, and this is why they are fighting at court for who was the one to develop these technologies. And yeah, that is the reason why you think, what is the use of all these rights? In the beginning, it's only money to be spent for the officers. So I said, no applications without fees. But if you have put a lot of effort in your inventions and what you are developing in your departments and research departments and research and development, And so, and you are deciding to, you're not only developing the things just to keep it in the cellar. Of course not. No. So you want to make money out of it. And you want to sell it. You will go to fairs. You want to find business partners and whatever. And so it's always better and easier if you have protected it. No? So not only for the partnerships, but as well if you're going to find a licensed partner, because you do not want to develop it further on by your own, you need someone else to do it. Yeah. And as well to, yes, try to pretend for imitators. It's not a security, but as you see it as a prime example from the Adidas, which is just for the trademarks, but it's not only the 3 stripes which are copied, it's yes, try to copy the whole shoe. So we come to that later, that there are some trials to how to defend against it. So it's always, so think about what is for your business, how is this, and for each business it might be a different answer to that questions, depending on the area where you are working or doing research. So which role does it play in your business? And not only today, but what about tomorrow? You want to keep your business for a long time, not only for 1, 2, 3 years. So you want to run it, you want to enlarge it, probably you want to work together with others. So this is an important part to think about. And so we can see this is finally, this is the part. It's finally a tool to make money. And this is the reason why they fight that much, because they make money out of it and everybody wants to defend his rights against the others or against the competitor. And important as well is to find out who is as well working in this area. And very often I see it, especially in research at universities, people are very, very familiar with all the scientific literature and they know who else, which groups are working in this area as well, in which country, at which university, whatever. But the biggest tool of information is in the patent databases. And this gives you a lot of answers to the questions, to find out who else is active in that field, who might possibly infringe my invention, but it might as well happen that you infringe the rights of someone else without purpose, without knowing it. And as well, it gives you a hint if it's possible at all to get it protected. Now, is it already known on the market, for example? No. So patent information is all the information you find in these databases. There's all kind of, yes, not only technical, but as well legal information. And these are the databases which are available. So there are a lot of national databases. ESPASnet is from the European Patent Office, but don't forget the national databases. There's for patents, and you have one for trademarks. There's patent databases for designs. So there's a good chance to figure out. So you can find as well the IPR help desk as how it is protected. And you can find out who is the owner, when was it filed, and so on. It just gives you a short hint of, this is ESPASnet. This is the system from the European Patent Office. It's free of charge, and so you don't have to register as a user. You can just easily access, and it's really easy to use it. So you can just put on your keyword and any kind of search term, whatever, just a word of the business, but always as well the name of an inventor or a company you are interested in, whatever. And then you get this as a result. For example, here were only two applications, And then you can get into detail, because they have as well the full documents in the database. And the full documents, and when there, in case there was an opposition, all the documents which are used in the process from the very beginning of the filing till the end. All the documents the examiner figured out in the search report, all the writings, the letters, forwards and backwards between patent office and an applicant. So it's not only the application, but it's all the huge information all around. And the same is for from the WIPO, from the World Organization, which goes worldwide, so not only Europe, but yes, much far over Europe. So you can see here the countries, South American countries, all kind of Asian countries, whatever. And so, but the way it works is nearly the same. So, and you put your search term in, the name of a company or any keyword, whatever, and then you can decide, do you want to search worldwide or certain countries, for example, and yes, which countries, and then you get a result like this for where something with digital scopes is applied for. You get the countries, the offices, and the companies who applied for that patent, and then you can go into each document to look out for details. Yes. It's a long way, but it's quite an easy way to find it out. But as well, you can get the information if a patent is, for example, still valid. Is it still alive? So what we had now in the first examples, it's just who applied for it, and what is the content of the application, what was written in it, and what is the all around. But very often you want to know, is it still alive? Who is the owner? In case patents are sold or a business is sold in a kind of merger and acquisition process, very often business are sold and all the knowledge, the patents are sold as well. So there might be a new owner, for example, and maybe now it's a direct competitor of yours, which has not been before. Or what about the countries? For example, in the European patent, if you cover all, you have 20-something of countries, and after a while it's expensive to keep it all upright, and so after a while maybe you decide, okay, I leave most of them away, I just keep 5 countries and that's it. So it's important to know, because then if you are having your business in one of those countries which are not relevant anymore, then you don't have to care for a license for this. So it's important to see about the legal status of an European patent or application, and therefore it's a European patent register. In a way it works like the other one, and it's the same, it's as well free of charge to be used, and it's easy to be accessed. You put a search term in it, and as well you get, or the inventor, whatever, and you get the results, and then you decide, okay, this is the one I'm interested in, for example, like this, and then you get the details. All the applicants, all the inventors, and the data. Was there an opposition? How many letters went forward and backwards between the applicant and the office? And is it still alive, for example? And yes, that is. And always the last event. Did they pay the fees? Very often patents lapse because the applicant does not pay the fees anymore. You have to pay annual fees, and there's most of the cases there's a certain time limits to repair that in case you have forgotten to pay the fees, and but there's always a limit to that repairs. So it may be if you just forget to pay and don't open the letters from the office which remind you to pay the fees, then it's done. So this might be important. For example, if you're in license negotiations with someone else, and you have they want to sell, someone else, company X wants to sell you maybe a certain technology, and this technology is covered by 5 patents or patent applications, then it's quite important to figure out in the beginning what is about these patent applications. Are they still alive? Or what is their geographical scope? And so on. And this might influence your license negotiations. No? Perhaps you might get it cheaper as you thought in the beginning. Yeah, search terms, yeah. So, I see we need a break, I suppose 5 minutes, because it's quite a much. So, this is what we had in the first hour. So, I tried to explain that IP or patents is not only a matter of, not only something which costs money, but which is an important part for the value of an organization. And then we had a look to the different ways of different protection tools which are available and what are the difference, and how to figure out who is as well working in the area, or if these rights are still valid or not. Any questions from your side? Yes, please.
If I personally have international trademark, what can I use? How can I use this mark? Only put on my visit card?
No, you have to use it. You are obliged to use it in a way. So after having registered your trademark, you're obliged to use it latest, I think, around 3 years after having it registered. To really use it to make a business, for example, or whatever. And it protects your business. So only a trademark without a business behind it is not really sense. It doesn't make sense. So you should have I suppose you have a business and then you give this a name, a company's name or a business name. This is the reason for a trademark. And that's the protection of your business idea.
But can you sell?
You can sell it, of course you can sell it. I remember, I think a couple of years, at least 10 years ago, Volkswagen, they had started to give the cars, the new series, these names of these winds, these African winds, like Passat or so. And then there was a guy who said, maybe they're going to have a kind of a series with all these additional names. And then he went to the office and had these, I'm not very good in geography, but all these other kind of winds, which are not only Passat, but further. He went to the office and kept these names protected. And then he went to Volkswagen and said, I offer you the trademark for these protected names. And they said, shit, we forgot to protect it ourselves. So, but there is a time limit because they were in the production area, or they designed and wanted to take these other names as well for the new series, but they forgot to protect it in time. So the guy was not bad. He earned quite a lot, I think. But you have to use it. So you can have it protect your business, and later on you might, yes, license it out or a product you're doing. So this is the reason.
Maybe it is my problem, but that I don't not see what can do my trademark for me. I have 4 years the national trademark. Here, spectacles. Here, I know it is a qualification. Yes.
Mm-hmm.
Yes. And unique design, but my personal human trademark.
Yeah, for what did you have the trademark for? For a product you sold?
No, personal.
Or a business behind it?
Personal trademark from Strasbourg.
Okay.
I don't know what is it.
I'm sorry, I don't know either, but...
Yes, the trademark, or no?
No, this is not a trademark.
Yeah. This gentleman, yes.
This is like from a passport, so the signature, and this is not the trademark.
As signature?
Yeah, like from a product, if you go to buy something in a shop, you have this code, this is the coding. It's not a trademark.
Yeah.
So, well, we had a misunderstanding. Yes, please.
Question regarding, for instance, company logos. Is a company logo automatically, once you put it on paper, something like copyrighted, even if you don't take out the trademark for it?
Right, it is, yes. It's copyrighted and in the very beginning. Yeah,
In the very beginning, so per se you don't need to go immediately to trademark, for
No.
instance, if the company is not big or anything like that.
It might happen that someone else is going to copy it and to use it as well and to have it registered at the office, and then it's up to you to prove that you have been earlier. No. So and it might, this is a bit more difficult if you have it just as a copyright. No? But per se, if you can prove it, so it's always important if you start a business, for example, with a name and you don't decide in the very beginning to have it protected, to collect everything, to collect that you used it. So not only on the web page, for example, or the product, or if you had any flyers where it was on, so collect it to prove that you have used it. And this is important as well if someone else is coming and saying, you never used your trademark. No, I can prove it. No? So.
Also going to follow up on that regarding something more complicated like industrial designs. For instance, something is being designed, but there's no trademark, there's no patent to it, but it has been put on a piece of paper, and let's say it has been used in a document, but not physically made. Is it also copyrighted that?
Copyright is nearly always.
But somebody can put a trademark on it, and then I would need to repair it.
Or design it, or design whatever, yes. So that was always important if you start something to keep samples. When you did what, and best is it's always to have maybe have someone to prove it as well. As you can show it, you have used it, and especially when did you use it first. So this is quite important. Yeah.
So as soon as if you publish something in a magazine or a newspaper, then you can definitely say it's already copyrighted.
Yes, yes. Per se, it's copyrighted, and yes. So keep a file of, or keep a magazine just to prove it. No.
You said that software cannot be patented. What do you do to protect software?
Usually it's protected by copyright. There are some efforts to protect it. For example, if you're developing a program, a computer program, and you are developing the source code maybe every day by day, so a lot of people say send a kind of, you can do it, send a letter to yourself, maybe every Friday. So what you did the whole week, you made it in writing, and made it in an envelope and send it in a sealed letter to yourself, and don't open it. So in case that you can show, maybe today the 14th, so this is the status and I can prove it. I didn't open the letter, so it can be opened by someone else. Then there are
Not an email? Not an email?
No email. Email is open. Email is open. You won't open or give it the source code to everybody. So a sealed letter, the very old-fashioned way. And another possibility is to send it to a lawyer. There are some patent lawyers who start to store that for their clients on interest. And I think in some of the Benelux countries they call it e-depot. So this is a certain way, but it's more for Benelux, also Belgium and the Netherlands. So usually, you do it as a letter to yourself, or you find a patent attorney who has specialized on ICT or on IT cases, and very often they offer this possibility to have it stored weekly in a way. For all details.
You can prove the copyright.
They can prove that you have really had it on that certain level, for example, at that date. No? So you won't send a letter every day, but maybe once a week, for example. It depends on the program.
If I apply for a patent, you're
country?
Yes and no, both. So if you go for a European patent, the first is the application covers all in the very beginning. Then you have a certain time limit to decide. Now, for the first fees, you have, I think, 7 countries. You can decide which countries you take. If you want to have more than these 7, which are in the basic package, let's say like this, then you have to decide. You have to pay fees. Not fees in the beginning, but the translations. Translations are the one which have to be sent in. And after the patent is granted, then it is not kept any further at the office, but then it goes to the different countries you have chosen. So if you have chosen maybe 7 countries, for example, then it goes to the national office of those 7 countries, and you have to pay the fees. Yeah. There's always annual fees, and they are paid till the end of the life of a patent. So it starts with year 3 after the application, and first you pay it to the European Patent Office, and after grant it goes to the national offices.
Do you see that it's competitive for the SMEs?
Pardon?
Do you see the way of patenting the product is competitive for SMEs? Are they able to pay those costs and protect their...
This is a matter of the companies. It always depends what you are working with. Patent is not always the only solution which is possible. Some countries, for example, they have these utility patents, which are a bit cheaper, but not all countries do have this possibility. I think there are just 16 countries in Europe who offer these possibilities. So it always depends on your business and on your product.
This European are going on to make some simpler process.
Yes, they are on the way. They are discussing this for 20 years now. Yeah. Though I hopefully it will be finished next year. I think it makes it easier, especially for these costs for the translations. If you have an application of, let's say, 50 pages and translated from German to English, it costs, to say a figure around, maybe 3,000 euros from German to English. Translation from German to Hungarian, 7,000. Translation from German to Japanese, 10,000. Now, say 50 pages. It depends on the language. So you can really get poor by that. Any further questions? Or let's have a 5-minute break for the moment, or what did you say? So now we had talked about the different ways to protect your rights and what is important to keep in mind. But to have it protected means you have sent a letter to the patent office. And then you get an answer, you get information that it was registered, and that you have a certain number and the date was registered and so on. And then there starts this bookkeeping in a way, the internal management. So there must always be someone who is responsible. Who is the person to send the letters to the office? Who is the person to open the letters coming from the office? And for most of the cases, there are any dates involved, dates where to pay fees, dates when to answer, and so on. And this means as well a proper management. But this is not only just the simple bookkeeping, the everyday management. It starts at least one step further on with a certain strategy, the strategy behind. So usually, this is what we call the management areas of an organization. It doesn't matter if it's a big company or a small company or a research organization. So you have the project management, you have the project administration, maybe you call it in a different way, but this is always departments you have with dealing with finance, with contracts, subcontracts, and reporting. You have a communication department, or at least maybe one person who is involved or responsible. And finally, you have the so-called innovation management with this is not only IPs and patents, this is as well technology watch who else is working in this area, and all kind of marketing and exploitation. And that's what we call the IP management in a company, in an organization, in a project. And we had these patent searches in the first part, and it's always important to think about, to know about the IP environment. Who else is active in the field where I am working? And therefore it's important to know what is the knowledge you have in your organization. Do you really know all the kinds? And what are the competitors doing? And then the second part is, how will you use your IP? Now, use means IP is all the knowledge you have. Will you go to protect it? Will you go to sell it? And so on. And yes, what types of IP are relevant for your business? And finally, is there any plan? What happens if someone else is using your patents, your rights, without having a license? This is the first part, means IP research, and the other one is the IP strategy. How to deal in general with that what I have. And so usually it's in general is to, what do I do with the knowledge in my company? How does it fit with my organization, and how can I do it and use it to improve the value of my organization? And so it's always, there is not one strategy for all. It's always depends very much on the kind of business you are running. And so some people go offensive with the strategies. It means they are actively buying the rights of others to have a bundle of patents or in a certain area of technologies. Others say, okay, we just protect what we have, and then we keep a bit away, try to avoid any risks, and so on. This is always a matter of companies' decisions. But important for a strategy are some of the areas is the geographical scope, the product branding. I will come to it in detail. The freedom to operate. Am I really allowed to do it? What about parallel importation? And finally, industrial standards. Geographical scope. We had the production as well. And which are the countries which are important for my business? Where am I going to produce or sell my products? But as well, are there some countries which are just important for strategic reasons? So this is quite to be thought about. And as well, think as well about the future. What is the status today? Countries which are important today, are they still important maybe in 5 years further on? Think about as well the political situation in some countries. Are they stable? Are they less stable? And therefore it's still interesting to sell products or not. The branding is, if you're going to brand your products, are there already the same brands in that country or not? And very often we have the name of a product, what you protect as a thing. Is it a name which sounds nice in your language, in your country, but it might sound very awkward in another language? I was some couple of weeks ago. I was in Finland, and there I realized a certain wording which is discuss the same word as the same written as in German, but in German it's a disgusting. You won't use it, not even as a product. Unfortunately, I can't remember, but this might happen quite often. So keep it in mind, and I think we had it with sometimes it for car products as well. They call it.
In Latvia,
Yeah.
Windows Vista.
Yeah.
It means chicken in Latvian. So.
Yeah.
Probably everybody knows that one in Latvia.
Yeah, so this, and though if you're going abroad, so think about this as well, before you spend a lot of money for applying for a patent or a trademark, especially, or giving a name for your product. Yes, freedom to operate means, are you really allowed to use this in that country, or is someone else having rights to use it? This makes it again important to go for patent and trademark searches, for example, to be really sure that you can use or sell your product in that country. And yes, parallel importation is if someone else, we have now become to the Adidas shoes, for example. So if they are produced in any kind of Asian country, for example, and then re-imported to Germany, to Latvia, where they're much more expensive, then this is something to be keep in mind as well, even if you are a producer of a cheaper product, because customs is always happy to destroy the things which are imported without allowance. So is this as well, if you're going to produce something which is cheaper than the product already known on the market, think very carefully to the markets you are going to enter, and if there are any rights of third parties. Otherwise, it might be a quick end of your business. Yes, industrial standards. As we call the DIN norms, for example. So. Or any kind of security for certain products, kind of product security, especially with children's products, children's toys. There are some standards which have to be kept, and these standards might be different from country to country. So it's important to know what the level or what the standards in the countries are where I'm going to sell a certain product. So this is the idea behind all the ideas which I have as a kind of a strategy and policy, and now it has to be switched to the everyday work. And so this goes into the everyday work in the staff. How is the staff or the employees, are they connected with these different principles as well? And so, because IP management can get a large business within an organization. So it depends if you're very active in a field, if there's a very active research and development department, for example, then there will be a lot of outcome of technical inventions. And if you're going to protect everything, then you do not need only one person, you might need 2, 3, 4, 5 person, internally, externally. This is to be decided. Can you do it on your own in your business, or do you need someone from outside, patent attorney, for example, and so on? And yes, in the very beginning, you need an overview. What do you really own? What does your organization really own? And if you really go into the details in the bookkeeping, you'll be astonished how much knowledge is within your organization without having realized it. This means as well, what is your organization doing? And the bigger an organization is, the easier it's to lose the overview, what the department is doing. And yes, very often there's knowledge which is just not realized as big knowledge. It comes. You realize something, that there is a lot of knowledge when people are leaving the company. People are leaving, and you say, okay, someone else is coming. This is technology, we have protected it, so person X is leaving, and person Epsilon will take it over. Here we have the description, that's it. You will be astonished that very often this does not work, because this is not only what is a process which is written down, it's the things which are between the lines, which are not kept as that or thought as that important, but would make those things work. And in general, we have 5 big areas. Independent, what kind of organization you have, big company, small company, research or production. You have always, the first step is to identify what is the knowledge we have, what is the knowledge which is created, can be protected, yes or no, and how. Then, yes, manage it. Someone has to write the letters to the office, someone has to open the letters from the office and to answer them. To enforce it, to protect it against others who are doing comparable things, and the IP exploitation, which means make money out of it. You've seen applications are expensive, and you put a lot of efforts and energy in your research and development departments, and you protect it. So you want to have a kind of return of your investments. You want to get money back of what you have been doing, no? By different means. And yes, for the identification, it means a review. No? So look around, what are the people working on? What are they doing? What is really the outcome of the departments? And then you go for protection, depending on the kind of invention you have. Then becomes the management, which includes as well to have a look what are others doing, to do a patent search not only once at the very beginning, for example, but do it on a regular basis. Have someone who is responsible for these kind of patent searches. Enforcement, have a look who else is working in this area, which needs the patent search again, and to avoid that you infringe someone else's rights, or have an eye on it if not someone else is infringing your rights. Yes, and the evaluation, exploitation of what you have. So how can I identify? So maybe start with the products and activities which are done in the company. We had it in research. When I was working for the chemicals company, which had dealing in research in Vairāk and developing genetic modified plants, so with different starches. And so we have a long process. You start to identify, for example, a new gene. You have to put the gene into the plant. You have to develop the plant. You have the plant and then extract the starch out of the plant. And then we have the products where the starch is used for. For example, we had these kind of puddings, and they try to have a starch in these new puddings that the pudding will keep like this and don't make whack now after 10 minutes and suck out, and it does not look that nice. No? So you have a lot of steps involved. You have the gene, you have the process to put the gene into the plant, you have the process to raise the plant, you have the way to extract the starch out of the plant, and so on and so on. So there are at least 20, 30 steps, which is all knowledge. And so it's all knowledge, and not everything is protectable per se, but in a bundle, but it's all knowledge. So it's a way to, depending on the organization, make a list of the products you are producing. The different kinds, and try to figure out what are the processes, and think about, is it all our own, or did we copy a process from someone else? Which is not bad per se, but just think about, is this process owned by us, or perhaps we still need a license from someone else because we copied their process, even if our product is a bit different. And so first of all, it's a collection of all what you have. What are the processes? Oops. And so if you can really do it like this, describe it piece by piece, about a certain process, which are the products coming out of it, and who is involved, which people are involved, and is it developed by ourselves and not. It takes a lot of time, but if you start to do it in the very beginning or do it once, it's quite helpful to get the overview and to be not surprised if someone else is coming and saying, "Oh, you are infringing my rights," and then it's easier to prove and to have it as an IP review as well, an internal. And that's what we call the IP review process. So we had it in that company as well, that researchers met once a month and discussed the new developments, and there was always an IP person involved, at least involved, to think about, are there already processes which might be protected? If you're going to change your the way how to produce something, is this your own idea, or did you hear about that from any kind of literature, or did you just copy it? So maybe we need a license from someone else, and so on and so on. So it means for an analysis you need a lot of people involved, or certain people involved. You need the leaders of research and development. You might as well, if there's a project, those who are the stakeholders of the project, and of course the management, so those who are involved in contracts and so on. So finally, again, just to figure out what is inside your business and what is owned by third party, what to do with the things you are owning. It's important as well to have clauses in employees. We were quite astonished when we figured out that even in big companies in Germany, a couple of years ago, it was not self-evident to have certain clauses for confidentiality, that people should not talk Saturday evening to the neighbors, having a beer about the fence. What are you developing? We had an interesting thing last week, that and that. And so sometimes they're quite astonished how things might leak. And so having a kind of confidentiality clauses is important as well. Not to be underestimated is employees' inventions. It's not always a big improvement in the process. It appears to be a small things, but which might save a lot of money finally and make a process easier, quicker. So, and have some forms for that, a kind of a system that people can inform the management about this, and it will be noted quite in detail who did what. Is only one person involved, or are a couple of persons involved, and so on. And and kind of about the kind of awareness within a company about that, because people are working in a company, and the knowledge which is created this is owned by the company, and this is the basis as well for the business. So by employees being aware of the knowledge they are working with means their own economical basis. Because if the things leak to third parties, competitors might become stronger, and the own company might get weaker, which means jobs finally. So it should be the people who work here from 8 to 5 and do something, but that what they are doing, the processes they are involved in, is the basis of the business, and is knowledge as well. Yes, externally means restrict access to information. Means if you're working or discussing, negotiating contracts, processes, license agreements, whatever, go for non-disclosure agreements in the very beginning, and be careful with all kind of IP. So don't have a third party access to your company's PCs, not even with a, with a stick thing. Huh? Very lot of things are leaking by that. That just copying any kind of information. No? So yeah, that's what we had. Try to protect everything and figure out that it's not owned by a certain third party. And what else? Yes, again, the databases. We had this in the morning, and so you can as well have a look to the national databases. Have a start like this, and you will be astonished how much you already find in the national basis before you go European whatever. And as well, it's not only for patents. You find as well national trademarks and designs, so everything. And as well, the offices give training. If you say, I do not have the time to get into detail of how to work with such a database, how shall I do it, how shall I manage this? For example, European Patent Office in Vienna, they give courses. You can go to Vienna and have a course on site. They can do it online as well. 1 hour courses free of charge. And so it's worth to find out where you can get help. You can't do everything on your own. And the bigger the organization is, the more difficult it will be to do it all on your own. So yes, there is support, which is giving, and yeah, don't underestimate the knowledge of others of these databases. We had it quite often when we get into writing patent applications, spending the money for the patent attorney for the filing fees, and after a year having the search report and figuring out, someone else, not only people from research, any company, and not everybody published in the database, some published in any kind of journals you are not aware. In the Siberian hunting, for example, you'll find articles about starch development, which usually you won't think, Siberian hunting. So sometimes it's by purpose, that people publish articles in very bizarre magazines to say, I've published it, but you can't find it. Not as easy as you would. Yes, further internal processes. Again, it's important that the company, that all the people working there, the employees, that they know about the strategy and about these measures, how to protect it, and that they know who they can inform if they have the impression that they made an invention, for example, or so. As well, increase the awareness about IP, that people really get the knowledge, as I said, this is finally important for my own job in the very end. And the knowledge which is created, don't have it leaked out, and tell about innovations and yes, even improvements, and keep it in the company, because it is the financial basis of my company or organization. So this means as well in detail, maybe those of you who have already worked in research at a university, they might know these lab books, for example, in paper or whatever, which was always important to prove when you started to do your invention. But it's as well a way to write down what is developed. And so, again, to note and to review what is known in the organization. So this is the lab books, which you might know. I had this, and my time to write it down was not very funny to do this every day. So, meanwhile, of course, you can do it electronically, and there are electronic databases which are in the same. You don't have to do it all by hand, because this is getting even worse to read the handwriting of someone else a couple of years later. IP and the team. I said it's not the goal that all employees become little patent attorneys in the company, but a certain degree of awareness is quite important, and therefore internal training is needed. This is we had this in that company where I used to work for a couple of years, that the management said, okay, it's training, we do it for the group leaders, for the department leaders. We don't need it for the technical assistants. What shall they know about IP? But the technical assistants, they were those to write the lab books and to write down what they were doing every day, which was the basis for the next steps in research or for further product development. And then I said, okay, no, I will go make some courses for the technical stuff as well, and to explain why they had to keep these bookkeeping and lab books notes, and that was quite important. And then I figured out that they didn't know that, and if they didn't know why they should do it, they just do it because they have to, but they don't put any effort in it, more or less depending on the personality, of course. But it was quite a help to invest 2 hours for the technicals, and it gave a lot of effort back. Because only if you know why you are doing something, you are more thinking about it. It sounds very stupid and simple, but it had not arrived at the higher management in that company at that time. So I was not sure if it had arrived later on, but I think it was, in any way, it was worth the effort. So I see. Any questions from your side? A little information overload, I suppose. And I think the idea was to have a longer break now. We have all the, if there are any questions from your side, so don't worry. So otherwise, just to have it on one look. And yeah, management, I suppose that's the points. Management within the organization. Important is the strategy, as I said, and how to deal with the knowledge which is created in general, and not the internal work, that is the management, but the big idea behind it. What is important for my business? Which countries, which ideas, and yes, which involves again the searches and comes down in the daily management of the knowledge which is used and created in a company. So, yes, please.
There's a sign saying patent pending. When can I apply it, and for what basis can I apply it?
Patent pending means that someone is showing that it is already, he has already applied for it, he has sent the application to the patent office, but it's not granted yet. So which means, however, it shows that he is on the way to have it, he has done the first steps for protection.
Why do they do that? You don't have to.
You don't have to do it. No, it's a kind of a personal.
Like to scare the competitor?
Yes, in a way. Maybe this might be a reason for that, to show that it's, don't even think about copying it, because I was earlier. I already sent a file to the office.
But you can do it as soon as you have this application, like the date and the stamp of
Yes.
application.
Yes.
But
yes.
then later you can withdraw it, so maybe that product wouldn't even get patented, right?
Yes, it might happen. Yeah. It takes some years. So if you're going to sell a license, for example, if there is a granted patent, then you would get, and then you're going to sell a license much more expensive than to sell a license by a patent which is just pending, because you never know what is the end of the examination procedure. So usually you start with an application which is that broad like this, and in the process of examination it ends up maybe like this, and but you don't know in the very beginning, and someone else who wants to buy a license doesn't know as well. So, but a license on a pending patent is always cheaper than on a granted patent. But yes, the background is just to maybe to scare possible infringers, whatever. Yeah.
And the cases where someone's not applying for the patents and still puts this mark patent pending on its products, is it illegal or?
I don't know if it's really illegal in that way, but so in case someone would be interested in that product, he would do a search on his own and try to figure out about the status of that pending patent. And if you find out that it's not alive anymore because the applicant has skipped it, then it's, yes, maybe it's going to have a bit more thing. So as long as you don't take money out of it on this basis, and if you're going to get money out of this by having, if you call it a pending patent, and it's still, even if it it's not alive anymore, so yeah, not really illegal, but it's not, yeah, it's in the gray area, I would say.
But when you do a patent search, you can only find those that have been, you can't find those patents that have been applied for but haven't been granted yet, that are in the research, right?
You can't find...
4 or 5 years?
No, they can be found. You find them. What you do not find are those who are younger than 18 months. No, because the patent applications are not published earlier than after 18 months. So even if the process is going further on. It's just the 18 months for patents. For trademarks, it's just half a year. As far as I know, it's a bit shorter. So.
Let's say you apply for a patent, and prior to publication, there's the kind of time where you don't know, but let's say if there's the part where you get the feedback or you pay for it to the patent search, you find out if somebody else has applied. But if apply for a patent today and a week later Joe Bloggs applies, do I get notified that Joe Bloggs also applies now? So in theory I cannot go to Joe Bloggs, hey, do you want to buy the patent?
Not at that moment, maybe later on, as soon as you know about it, because you apply for a patent and someone else is doing it a week later, and you do not know about each other, which might really happen if you are...
During his patent search, he will know that I did.
No, because everything which was published in the first 18 months, even if you're having the patent search in this first time, so a patent application is published after 18 months. This holds true for all, and until the end of these 18 months, nobody will know about your application. It will not be published even in the search files of the office. So nobody will know it.
So, for instance, if my search is, let's say, if mine is delayed for whatever reason and his is not, so applies, he gets published before me.
Yes.
He gets the prior right before me, right? Then.
No, the right is always the date of application. The application date, that is the important date. That is the priority date.
Not the publication.
No, the publication not. No, so it's always the application date that is important. And then it's a kind of it's not grey, but it might be difficult with a novelty, but this is a matter of the patent law case by case, how to deal with these cases, and we will have to compare, is it really the same invention or are there differences, and so on.
Sorry, is there option that this period of 18 months would be, for example, 2 weeks?
You can apply for that to have it published earlier. That is possible, but I think not after 2 weeks after having applied for it, because it's a process of printing. So this is.
But if it's possible.
It's possible to have it published earlier. Yeah. That you have to pay for it, of course, and extra fee, I suppose. And yes, but per se it's possible.
Because I wonder, these big companies like Samsung, so they might pay to have it quicker.
Sometimes it's you do not want to have it quicker. You just want to keep it to 18 months because this gives you room for further development as well. And Coca-Cola does not apply for a patent at all. No? So because after 18 months it would be published and everybody can copy it. Of course, need a license, and after 20 years it's gone. It always depends on the business. And they say, okay, after 18 months, this gives it's hidden for 18 months, in a way. But there are sometimes cases when people want to have it published earlier. For what reason ever, I don't know yet, but I know that this is but it's possible. It's possible to have it published earlier, maybe after a year. 2 weeks is a bit short, but I suppose after half a year, latest, might be possible. Any further question for the moment? Yes?
I'm wondering about the non-disclosure agreements. What's happening if someone is breaching this agreement? What kind of responsibilities do the negotiation partners will have afterwards?
What do you mean? It means in non-confidential?
NDA, non-disclosure.
Yes, non-disclosure agreement?
If someone from negotiation partners is breaching this
Yeah.
agreement, what's happening afterwards?
Then you have a problem. You should have it in the agreement as well. For those cases, if one of the partners is breaching the agreement, what kind of maybe damages he has to pay, for example. So this should be an important aspect you are mentioning. So this should be a part of the agreement. Yeah. So let's start with part 3 of today. I hope you had some refreshments, and it's quite a lot of information, I suppose. We go into advanced IP practices, so it means IP exploitation, how to make money out of what I own, IP enforcement, so what to do if someone else is infringing my rights, what shall I do, or maybe you infringe someone else's rights. And in the very end, I give you an overview about the services of the IPR help desk, which is quite more than being here like today, but as well we have, in a sentence first, we have on the homepage a number of, like a library section for those of you who are say, okay, nice idea to have a confidentiality agreement, but how shall I manage that? What shall I write? What has to be in there? And so we have a library section, and you find a lot of templates for all kind of contracts and agreements. This is what I will explain in the end with the IPR help desk services. Yes, again, we had it in the last part. What is the idea of IP behind? If you do a lot of efforts to protect it and to make notes, what is in your business, and you go for protection, which is a lot of work, which costs time. So you have the development, you have the protection, and again, it's just to make money out of it. So that is the reason behind. And protected IP gives you always you are more on the safe side. If you are negotiating agreements, if you're negotiating business opportunities with third parties, and especially if you're having products to sell, if you're going to fairs, for example, to trade fairs, to sell the product, and if you have a protected product, it's always easier to go against those who are copying it. No? So we'll come to that. There's one initiative, I know it from the trade fair in Frankfurt, Germany. They have an initiative. It's called Messe Frankfurt Against Copying, and they have a kind of a mobile lawyer service on the fair. No? So in case. Usually it takes some time if you can go against it, it's a court action and so on, but for these fairs they have a certain agreement together with the customs as well, kind of this mobile lawyer service, which means if you're an exhibitor on the fair and you realize, oh, over there are 2 or 3 who are copying my products, you inform that lawyer and prove that these are my rights. They can just check it, counter check it via database searches, and then within a couple of hours or one day, these other booths of that infringers might be closed down. This goes quite easy, and this is especially important for those when infringers come from other countries, especially from other continents, which makes it much more difficult because and it's easier to have them closed down on the fair than otherwise you have to go to any kind of Asian, African, whatever country, and which makes it difficult. So, not at all. It's important to know what you own, to have it protected. It always gives you a better. Mostly, it gives you a better starting situation for negotiating and for discussions with third parties. But this is a matter you have to be sure on your own. So how important is it for your business? And this might be different from business to business. And yes, as a strategy to make money, and it's a trading chip. Finally, patent laws are trading chips. To sell it, to sell the whole business, or just to sell that technology, or if you want to keep it, but you can't develop it because you don't have enough people, for example, then you can license it out. As well, it's a matter, don't underestimate this. This is the same with having a big car instead of a small car. No? It's a bit of impress others. And especially if you have a business and you're thinking about just to it might happen that someone else wants to buy your business, or you want to sell your business for any reasons. It's always better if you have a bundle of protected technologies instead of saying, okay, yes, we have developed that and that technology, but we didn't protect it, or not as well as the products out of it. It gives you a better situation for negotiation as well. And all kind of due diligence procedures is always a matter of how many protected rights are behind it. I had this, the company I was working for, they do these mergers and acquisitions. Yes, they do it quite often, and the place where I was working, and it was closed down as well, and this due diligence, it took weeks to just really to figure out what the rights are there, and as well what is the worst behind it. And yes, the more legal rights, the more applied patents or granted patents and registered trademarks and so on you have, it looks quite better and makes the company much more valuable. That's it. And as well, it might confuse real. This is the reason why someone puts on his product patent pending, for example. No? So to confuse someone else, or just to show this is my area. No? So. And yes, this is what exploitation means as well. As simple as this, to make money out of it. So this is the key idea, exploitation, to get a return of the investments. You have not only the application costs, but everything which is coming first before the application, all the efforts you're doing in research and development. And yes, for the exploitation, then it comes to a point that you have to decide how you will do it, and can you do it on your own? Do you have the capacities to exploit it on your own? Is your company big enough to go into each possible market, for example? And as well to decide, do we really go into the public? Shall we commercialize it at once, or shall we keep it a bit for further research and development? Which is not an easy decision, and it really has to take some time to think about how to do it. And then, yes, protect it or not, keep it secret, for how long? They have a kind of an internal process to discuss this every 4 weeks or 6 weeks, whatever. And if you are going to exploit it, do we have the capacities? Do we have people who are really familiar with how to do it with the markets? Or do you need someone else to support you, or to do it together with someone else? And again, it's always, I know I'm repeating myself by this, but this happens quite often, that someone gets it. Okay, you do take care of the patents. This is quite astonishing, because there is such a value behind it, and just to give it to someone else, who, it is not the proper way to how to deal with it finally, you know, because this is the basis of your business. So you need to define a proper structure within your organization, or you have to decide, okay, we can't do it on our own, we don't have the capacities. We need someone else. We need to work close together, for example, with a patent attorney who is quite having a big mandate for us, or whatever. So it doesn't matter how you decide, but you have to decide it, and don't underestimate it. And yes, exploitation, in case you realize, yeah, it might be an interesting market. We have a product which has a big market. So decide as well, can we do it on our own, or shall we concentrate on certain markets, for example, and work together with others for other countries' markets? Is the language better, and it's a kind of other business behavior in other countries, and therefore it's always helpful to have someone local but this has to be done in writing as well. Who is your partner, and for what conditions, and so on and so on. Or you give it away completely, no co-exploitation, but exploitation completely by a third party, which means yes, either you sell the business, or you sell the patent rights, whatever, or you give it away as a license. So you still are the owner, but you give it away as a license. And as well, this is not done easily, because you have to decide as well to give it to just one third party, or to several, so exclusive or non-exclusive. So to give it to one party has some risk as well. What shall you do if they don't exploit it that well? Then you don't get any shares back. So it's important to have a look to that partner you are planning to work with. How does this company or this partner work? Is he successful in his business, or will he? Do you have anything in your contract in case they won't exploit your business that properly, that you can just get it back and give it to someone else? So this is quite to be quite important to think about that properly as well. So we come to one of the possibilities is a joint venture. If you're going together with someone and exploit an activity together for quite a limited time, or for a limited technology, and so you say, okay, we're going together, we have different knowledge, and we just put it together and do it. And yes, usually you try to do it on a long term for that special business, and it's an advantage if you go into different different countries. So you can just broaden it and have someone who is from the local market, who knows the local behavior, the local culture, how to deal with it. Or you go for the licensing, and this is another thing. So there are a lot of models. I will just come to the main three basic ways of licensing, so-called the business licensing, cross-licensing, and assertive licensing. Business licensing is just you give someone a license outside of any kind of further contracts. So someone gets a license to exploit your invention or to sell your invention or your product, whatever. And there's always a question how to find a licensee. That's what the question we often receive. How can I find someone who can exploit my invention? And usually you have your business contacts and you know, okay, those might be the ones to exploit it. Or you have to go via the internet. We had one case that was as well in this connection of the Messe Frankfurt against copying, that in a fair there was a kind of a household fair. No, it was a Christmas fair, Christmas and decoration, something like this. And there was someone, a French company, who said, there is someone who is infringing my rights. They have the same decoration as I have, and here I can prove that I was the first one to do it, and I have the rights. And then it came up to the other one. The infringer was a German company, and they were completely astonished. They didn't make it by purpose, but they didn't know about it, hadn't made any research, nothing. So, and then they said, okay, then yeah, of course we closed down the booth or so. And then it came out that they said the owner of the rights said, it looks quite nice how you copied our things. And on the other hand, in Germany, our business does not run that well. So maybe we can get together. And finally, it ended up that the Germans become the licensees of the French company. And so it was not a real business contact by that. It was more a kind of infringement case. But this happens as well, that if you are not very well known about what is going on. But so that find a good end with this case. But usually you have your business contacts from the networks and how to go on, or make so-called internet searches about knowledge transfer associations. So there's this Proton Europe. This is this is funded by the European Commission. They started that, I think, 9 years ago, in 2003. To give information on that. Then there's called the German Technology Service. They do this as well, where you can as well go into detail of what kind of business, who else is working in this business and who might be interesting for further contacts or for further deeper contacts. Or you go to the Enterprise Europe Network. So, like LIA, they have the most information about people working in this business and get them together. Are there any questions from your side? Yes, then we come to a so-called assertive license. This is a license with infringers. So with the example of the German and the French company, the Germans infringing the property rights of this French company. And so it might be a possibility to avoid as well any kind of court actions, which are usually quite expensive. But of course you have to decide, you don't give it away for free. And even if someone has infringed it, the Germans, they had to pay a certain amount of money because they had infringed it for a longer time. And even if the French just realized it on that special fair, but this was a process that was quite a bit, some years old, so they get a kind of a remuneration for the years. They had already sold the Germans had already sold these products without informing the French. This was income. People who are buying at the German company, they don't buy at the French company, so they have less income, and they buy the copied product, and by that it was a basis as well for further agreements. And yes, how to identify someone who is infringing your business is not easy. It's not easy, and you really have to be sure. So people who are very active in their business, they go to fairs and they know who as well is working in this area, and you will just have a watch out on catalogs and new product styles and as well, yes, databases, of course. Again, the databases, I was telling about who's as well working in this area. And as well the analysis of products. And the point is, infringement is not only the thing that money goes away because they don't buy the product from your company, but from someone else. Very often the infringement is it's a copied product. We have it with a brand, with the Adidas shoes, it's a copied one, but of course it's produced much more cheaper, and by that the quality is worse. And this gives, for those who are not familiar with these cases and don't go too much into detail, it's an image which is damaged in a way. It's not only the loss of income, but it's as well the image of the company, which is damaged by worse products. And this is often to find it out, and very often it might be a security problem as well if you have a copied product. No? But quite often it has to be analyzed very, very, yes, exactly. Sometimes the copies are simple, you can see it on a glance, but sometimes it's very elaborated, and so it really needs a detailed analysis to find out if it's really a copy and by whom. Cross-licensing goes as well to avoid infringement, more or less. So it's a license between two parties, is on the same level, and usually it's free of charge or against commercial things. It happens quite often like in the car industry. They have it quite often that the companies, they give each other a cross-license because they use the same basic technology, for example, for the light systems, and it's always, sometimes it's getting difficult to figure out who was first, because much of developments happen at the same time, or people are giving each other, are switching from one company to the others, and to avoid all these long-term court actions, which are quite expensive, then they give each other a license to avoid all that. Because court actions are expensive, take a lot of time, and block the energy within the company. So if possible, very often in some business areas, they try to avoid it by cross-licenses. Another thing of license, quite interesting. I think who of you has an iPhone with him? If you have on the map, you see there's a picture of the clock. You see it? And especially from the Apple iPhone. And the interesting thing is that Apple has copied that clock without having a license, by the way. And
from the subway station, right?
Huh?
From the subway station.
It's from the Swiss train system. It's owned by the Swiss. And they wrote a letter to Apple and said, by the way, we would like to inform you that the symbol you are using is owned by us, and since I don't know how many years, and it's protected, and you would be really appreciate if you, yes, send us some money for that, in the amount of this and that. And because Apple is very much against people who are copying anything which looks like an apple, but they overlooked that the right of the clock of the picture. 70 millions. It was quite done smoothly. There was no big court action. There was nothing in the papers. It just came in the very, very end when it was more or less finished. So, and they happened like this. Yeah. Yes, it's always a matter of business decision how you deal with licenses or keeping away or give it away, and because it's not only one thing, only one license. It's always a combination of knowledge which is giving away. So if you combine it and work together with someone, it might be positive for both parties. If you combine technologies with a partner, or combines the know-how, and if it goes together. And for the one who is giving away the license, the licensor, it's easier. It's an advantage in those cases if the investment is not done by him, and so the licensee saves the costs for the development of the product or the process, and the licensor saves the costs for going to the market. But there's always a risk, of course. What shall you do if the product does not go that well on the market, is not sold that well on the market? So this is a risk for the licensor to take over, but as well for the licensor. The point is, what does the licensee do? Is it really going to commercialize, to use the license, or is it just buying the license to knock any competitors out? No. So this is quite a risky thing, of course, for both sides. No? But so you need a very elaborated contract and to write down all the things to be done between the both parties. Now, what happens if the product doesn't sell that well? Why doesn't it sell that well? What are the efforts to get it sold? Does the licensee really put in all the efforts which might be possible or usually done? No? And so it's really important to take a lot of time to go into the details of such a contract. Oops. So the person who has a license now, you are selling the license to, he might become a competitor. No? So are you really sure that he won't be a competitor? So it's worth to think about this point as well. And in case it might happen, go this way, what shall you do? Do we have any strategy to deal with that? And as well, if this is the best licensee, are there other possibilities? Are there further partners or are possible partners who might become a licensee as well? No. So what are the criteria you have to choose the proper licensee for your product or for your process? No? So bless you. So it's as well important to think about this. What are the criteria I have? Now, where is the competitor? What are his business areas? What is his financial potential? How long is he already on the market? Is he going probably in areas which might be difficult for me because he's getting a further competitor, and so on and so on. So think about potential business partners or licensees quite properly to be sure, because it's not easy just to skip a contract after it has been signed. So yeah, so if you bind too early to a certain licensee, yes, it skips the opportunities for others. So the so-called risk management, this is an important aspect, is to write this down, to discuss it first internally into your organization, and then figure out which is the best way to scrap to draft the template. Are there any questions from your side? Yes, please.
You mentioned that the automotive industry uses free cross-licensing.
Very often, yes.
And I was wondering, is it for natural popular that industry? Why is it such a trouble field in IT industry when they're fighting?
Sorry, I didn't catch the last part.
As the IT industry, like Apple, Samsung, and so on,
Yeah.
they're fighting as much as they can, even though effectively they should do the same.
This might be a kind of a business culture. So I know it from this cross licenses from the car industry. They do it. So this might be different from business to business, and it depends on the end product. In the car industry, it often goes for parts like the brakes, for example, or the lighting system, which is yes, a part of the product, and they originally sometimes they develop it together at all in the very basic aspects. And then that goes to different ways, and maybe it comes together. It's a matter of the business culture as well. So as far as I have heard, that Samsung was much more in the way to go for an agreement with Apple, but Apple was the one who did not want to go for an agreement at all. So this is a cultural thing as well.
Did the car industry stop this free cross-licensing long ago?
As far as I know, it's. I just know it from, I think it was from between Volkswagen and Mercedes. They did it for certain things, and I can imagine that others do it probably as well. I think they started it 10 years ago, so more 5 to 10 years ago, or something like this, because they realized how much money it costs to go for these court actions, and how long it takes, and how much energy is binded by that. So. But this is always a decision right from the company. It was not me. There was another question over there? No. Then let's get to enforcement. I think we have already mentioned a couple of aspects concerning patent enforcement and infringement, but it doesn't matter. It's a very, very interesting and deep topic at all, and a lot of time at court, at the European court and other courts are quite because of IP conflicts, whatever. So usually, as simple as it is, someone copies your invention, and so this is the first step for an IP conflict as well. The use without having allowance, or same invention but different inventors at the same time. So we had it very often in Europe, as I said, and in the most of the countries, the patent is first of all 20 years, and it starts with the day of filing, 20 years after filing. And And the patent is published after 18 months. Up to, I think, 3 or 4 or 5 years in the US, it was a complete different system. They had the system of the patent is granted for 17 years after grant. So this is quite a complete different, there was no publication. There's publication after grant. And so this was a lot of conflict as well. And they had a system, in Europe was the first to file. The person who was the first at the office with the stamp and the date is per se the inventor of the first idea. In the US it was the first to invent, which is quite difficult to prove, because when you go to the office, then the invention is already finished in a way. But the first ideas of the invention was a year ago, 2, 3, 4, 5 years earlier, depending on the technology. So how to solve this with the first one? This was the idea, the reason for all these elaborated lab books, for example, that you have to prove that you are really made the invention first, earlier. And this was a reason to have it written down very properly, all the kinds of trials, what are you working with, what was the method, when did you first realize it might be an invention. These are cases and questions where I think patent attorneys, especially in the US, they earn huge amounts of money to really prove this. This has changed, for heaven's sake, this has changed a couple of years ago. So both the Europeans as well as the US have the system of the first to file, and as well in the US they took it over the 20 years after filing. Because after they have changed their system, a lot of kind of submarine inventions came up. Because you can, if you make a patent application and you have a long process of examination, then you can make parts out of your invention for some reasons in the run of the process. So this was quite done quite often in the US. So a part was granted, and then you knew about the content, but there was still 2, 3, 5, 4 parts, whatever, undercover, so-called submarines. And so you have never been sure, as European, for example, so what is the range of the covered invention? Will there still be something popping up and company X says, edgy? So we were first, you can see it here. Very, very difficult. But this is done. Of course, it still might happen that 2 inventors sitting in 2 different areas in the world and working on the same process, they are going to file it at nearly the same time. And they don't know of each other's filed invention. We have the thing with the counterfeiting. We had this with the Adidas shoes, what you mentioned. And this is always a matter of infringing of a trademark or copyright. So if you copy a pair of sport shoes, then it's a trademark. And so it's a different termination. Say counterfeiting as soon as trademarks are involved, and we say infringement as soon as technical inventions, e.g. patents, are involved. So and usually all of this is the non-authorized use. This is the background. It doesn't matter if it's a patent or a trademark, the non-authorized use, that is infringing, finally, infringement. And as I said, it might be possible, it depends on the case, to take a license or to give a license, whatever, to avoid a big court actions. And it's very important to really think about an infringement properly. Even if you have the impression someone is copying your invention, you really have to be sure if it's done. Maybe it's really a thing of the cross copying, or one has the main process in the very beginning, but perhaps or you are the owner of the main process in the very beginning, but are you really sure that all of the process parts, process steps are really developed by you or not taken over by someone else? Or if someone else is doing an improvement, so you have the basic technology, but someone else improved it, and which gives a plus and more relevant aspect to sell that developed product. So we're coming up with a cross license, and as well a possibility to avoid any kind of expensive litigation at the court or whatever. So if you start to figure out if someone has infringed your rights, you will start with letter of demand. You will not go to court first. No? So just be careful to be really sure. You would send a letter first and ask or tell someone, I'm believing that you are infringing my IP rights, so I have an application or a patent with number that and that from that and that office, and you can send a copy of the patent application with you, and then ask this third party to stop selling this product because they are, in your opinion, they are infringing your rights. And of course, you have to give a time limit. No? So you have to give a time limit. So I ask you to stop selling this within the next 10 days maximum. No? And as well, give me an information where you have the places where you sell it, no? And the amounts of selling. In case this does not happen and there's no reaction, or you're not convinced that it is right, and this ADR, the alternative dispute resolution, is a real good possibility to avoid any kind of court actions as well. It's like a mediation, but in the difference to a mediation, arbitration is legally binding. So it's not for free. It costs a certain amount, but it's in the end it's much cheaper than going to court, and it is quicker. So is this a well possibility to get both parties together? Because as soon as you have written a letter of demand, the other party cannot say, okay, I haven't received the letter, and I don't care what you are saying, I'm not interested. So as a second step, after having written the letter of demand without any answer, possibly, you can suggest for an ADR and say, okay, we want to solve it, but my offer is to solve it on a friendly way by this, and not going to court. As I said, it's legally binding, and yes, for example, the WIPO, they have this kind of arbitration mediation center, and I think just a couple of weeks ago I talked to a French attorney who was working there, and he said they really get it, 80% of the cases they can solve it very calmly, and that all parties are quite happy. And they have the advantage, they have nearly all languages present. So you don't have, especially if you have court and patent actions, and where very often it's a matter of the details of a description, and then not to do it in your mother tongue might become difficult, and might be always a purpose or a source of misunderstandings, and therefore they have nearly the most popular languages. I think they have 50 languages present there, so this is quite helpful to get it solved as well. And there's another, when I was thinking about language, this is often a problem of the translations, of the patent translations, because usually you file a patent in your mother tongue, in your company's language, and then it will be translated by official translators, which does not always mean that they really translate it in the proper way. And very often you have court actions only because the translation is misleading, which you didn't know, because even if I have a patent application and it's translated in Spanish, I have no idea what it means in Spanish. Even I wrote it in German, but so how shall I know if they translated it in the proper way? But there are quite of these translation mistakes. Yes, this is, I think, at least 20% of court actions have this background of translation problems, which is figured out later. So, and for that, so WIPO, they have said most of the common languages are present there, so it's easier to get it solved as well. In case this does not work, or another possibility is the so-called customs notice that try to have it, to keep an eye, it makes the information, as a patent owner, you give the information to the customs and say, I know that there are a lot of jackets coming from Nepal, for example. Last year I was living had a project in Nepal, and so I know that you get a lot of, for the usual sports companies, you get easy copies for very little amounts of money. You can buy it over there, and sometimes the customs have an eye on this as well and say, where did you buy this jacket? No. And as well, they can, yes, keep the goods at the entrance of the country. So I know from a guy from the customs who said they once had a guy coming in from, I think from an African country. He appeared a bit strange, so they asked him to open his bag, and then there was a lot of these small crocodiles, Lacoste crocodiles. All a sports bag full with crocodiles. No, it must be around some thousands. And what are you going to do with these crocodiles? Oh, I'm a collector. No? And very convincing, and said, okay, I'm not sure that you are really a collector of these small crocodiles. So the purpose is quite a different one. So you see Lacoste shirts, usually they cost around, I think in Germany, between 40 and 70 euros, depending on the way, and in some countries you already get them for 5 to 10 euros. So we get a shirt, a polo shirt, which is with a crocodile on it, and which is sold for 5 to 10 or maybe 15 euros, so at least a third of the usual price. I have heard that some countries do it in another way. So there was an example from Switzerland that incoming planes from certain countries, they are checked much more carefully. Countries where you can get maybe leather goods for a very small amount of money, and they have changed it that if you're coming from such a country where you can get a Louis Vuitton bag for 10 euros, for example, or 20, and you're going home to Switzerland, for example, then they have an eye on certain areas, and then they ask you, where did you buy this nice bag? And say, I bought it in Zurich 2 years ago, and does not look like being 2 years old. So would it be possible that you bought it in this country where you're just coming from? And then it's up to you to show that you really bought it 2 years ago. So they keep you on the airport till you have anything to prove that you really bought it 2 years ago. Otherwise, they say, okay, it's not only certain money, and so yes, so it's up to you to prove it. And this is all measures to get people, yes, to avoid this behavior. Just to say, okay, if I'm going and buy a cheap leather bag, which is a copy, it's not of course, it's not an original Louis Vuitton bag I bought in any Asian country, for example, then I have to take into account that I might get real heavy problems at the customs, and they keep me here. So it's good to know. Go. Yes, civil actions is, of course, if you can go to court and file a lawsuit, And very important is the damages, the compensation, and because someone else who is selling a product which looks like your product, this is the money you don't earn. No? The money someone else earns, and so it's a matter of how to count these damages to be paid, and one tries to figure out the profit someone else has made, and this is a profit the owner of the rights hasn't received. Any questions from your side? I just tried to give a rough overview about the cases, please.
Yes, how far does it go, for instance, on the individual property rights? Let's say you have a nice example of the quite unique looking bicycle over there. Let's say if, whatever, the height of it and the central axis is a little bit shifted to one side, and instead of being red, it's charred black, whatever. And you have a patent, trademarked everything, and you say it's a property right infringement, but they go back, no, it's not according to your specifications. Like, is it a gray area? Where do you?
It's a matter of you really you will compare both bicycles and to see how big are the differences between the two ways, between the original and the potential copy. So you have to figure out from the so-called original, what are the key elements, who make it that unique, and how much of the key elements are maybe changed in the second edition and in the potential copied bike, and this is a matter of to compare this, and if it's only very little things, then we say, okay, it's a copy. This is just didn't make an effort to change that much. This is quite a copy. But this is a case-to-case decision. So we will really take both bikes and compare step by step the overall appearance and the details. Yes.
Do I understand well? My personal international mark is not my intellectual product, and I have not right to use as a commercial mark. Yes.
I'm not sure if I really.
My mark, international mark, is not my product mark.
Yes.
Not my business product. Yes, and I have not law. I have not right to use as commercial mark.
Yes.
Yes. No, I don't like to conflict with sword side.
I'm sorry, I'm a bit lost.
Okay. After your lesson, yeah.
So usually if you have an invention and you have a certain amount of countries where you protect your invention, where you have the law, and these are the countries where, you have the law. Those the others, someone else might produce the product, for example. So, for example, if you have a patent for Latvia, someone else can use the product and sell it in Germany, in France, in Poland, for you. No? So, if you have it just in Latvia, then nobody else is allowed to do it in Latvia too, but can do it in another country. And as well, if you have an infringer, if you have maybe protection in 5 countries and there's an infringer, you have to go do it country-wise. No? So you have to do it country by country to follow up the infringer. Is this the answer to your question? Okay. further? Yes.
About those illegal copies, then if customs has the rights to stop me at the airport, does it mean that the using of this copy also is illegal?
Yeah.
Okay.
Yeah. Because it's always, if you use it, you must have bought it, or someone must have bought it, unless you couldn't use it, and this is always the money which is not owned by the original producer. So I think per yearly, sports shoes is a very good example, because this is quite something which has happened very, very, very often. And I had a picture about that customs destroy every year, I think, 1 million pairs of sports shoes, for example. So which are just copied and coming from other countries.
In case of the retail, if I find my product, for example, I don't know, in Poland, it's exact copy with different logo, then can I force the retailer to stop selling this product, or he's not responsible about this retail thing? I have to go to his manufacturer, whatever, who he bought it from, and then force him to withdraw the products from those retail.
It's as well a matter of the national law, how it is. But usually, of course, you start with that person who is selling it. So, because this is the person you see, he has the same product in his shop. And then you have to go back, and he says, okay, I have just bought it. But usually selling a stolen product does not help you for not being brought to court. So even if you say, I'm innocent, I just bought it, but this is not does not protect you. Because you are still the dealer of a stolen good, more or less.
I also have one question. There are some things you said cannot be patented in Europe, like business methods, but can be in US. So if it's a business method, for example, that's patented in US, but I'm a European company, I can use that business method in Europe.
You could do it, yeah. If
it's legal to do that.
Yes, yeah. If it's not protected, of course, the company who has protected it in the US will try to maybe to apply for it as a first step. So, but to be really sure, the best would be just to get for a license anyway. Otherwise, it might happen that. You get a letter from the attorney, and this binds a lot of energy to deal with it and to prove that you are not the owner. And it depends as well on the company's behavior. I said with Apple, so I know there's a case of I think it was in Berlin, a young lady who opened a cafe, and she called the cafe thing like Apple Cake, or Apple Child, like something like this. And selling mainly Apple products, Apple cakes, Apple juice, and so on. And she had a logo of like a shadow painting of a child. That's the things. As soon as she had opened the cafe, 2 weeks later, she received a letter from the Apple's patent attorneys to stop that business, even at the cafe. And she does not have anything to do. She does not offer any Apple. Seattle's Apple products, but just simple cakes. So they try to get the letter to stop that business, not to use the logo. And it was very different logos. So you can't say, okay, this looks like the IT Apple's logo. So there's no danger of to mix them up or the business up. But that's the way, like some countries just fight against any even far away potential users. And you see, as I said, with the example from the clock, so in other cases they are a bit more relaxed as far as the right of others are concerned.
Yeah, they're probably afraid to make a precedent that there's a
Yeah.
precedent and somebody used it,
Yeah.
and in the future can be used against them.
Yeah.
One more question. Maybe it's something related to the clock thing. I have a product which is design is registered in the EU. Now I'm going to Russia to meet the new customers, and my design is not registered in Russia. So this is a home appliance hotel. And does this copyright works globally? So can any of Russian manufacturers start producing this product, telling me that it's not registered in Russia, so I can easily make the copies?
Yes, this might happen. You can try to say, okay, you have already developed this much more earlier, for many years earlier, but it depends if you have already used it in Russia as well, even without having a...
It's registered and known and manufactured in Latvia and in the EU. It's new for Russia, it's a new product which is brought to the Russian market, and it's not registered. So can the Russian distributor say, okay, it's very nice, I will have a Russian factory to make this product for me? So
It might be. So it's always important to keep the samples you have started in Russia with, even without any registration. But it depends on the Russian law. It might be in the worst case, you have to go to the court and to prove that you have been earlier on the market, that it was your idea, even if you didn't protect it via trademark protection, for example.
So this kind of copyright idea works there?
Yes.
The same for Switzerland, for example, which is also is not the EU.
Yes, but if you go national to try to follow up infringers or to protect your law, it's a national case, and that is though you need someone, you of course need an attorney from Russia or Switzerland who is familiar with that law to support you and to protect your rights finally. No? And it's because in national law there might be differences, and so they can't be made in a general information about it, how to deal with it. So in the end, I think it's the end of the. So that's what we had. I will just come to the services of the IPR help desk, just to show you that it's much more than like being present as today. These are all the services on a glance, and I think you have the flyers. So if you're not, I still have enough of them, and you can see an overview of the services on here and the IP address on the other side. And a bit more in detail, yes, this is a general point. All the services are free of charge. So we have the website, and you find over here, you'll find the upcoming and further going on points like the library, as I said. But it starts with an overview of the services, and you can go deeper. And if you just register, you will get as well the newsletter. The helpline is a very important thing for all of you who have upcoming and further questions. So at the helpline, we have my colleagues from the helpline. They are lawyers and have additional studies in patent law, so they know what they are speaking about. And you can contact them. You can contact them via fax, email, or phone, and send a question, or maybe if you have a paragraph in a template, in a contract, and you are not sure if it's the best wording, so you can contact them, and they will answer you within 3 working days. So use the service. We have a magazine, the Bulletin, 3 monthly magazine, which comes electronically, and as well we have these publications, so these fact sheets. You find it on the library section on the home page, and so it means the fact sheets they're published once a month to different aspects, like IP in brokerage event, or how to search for trademarks, or what to do in collaborative projects, or what is relevant in IP in the project life cycle, how to formulate a confidentiality agreement. All these topics are dealt with in the fact sheets. I think I have. Yeah, especially for SMEs, especially here, the guide for SMEs, how to manage IP in FP7, so all those who are involved in European funded projects. I have some here, so just feel free. Yes, like IP issues in brokerage events. There's always usually between 8 and 11 pages, so it's quite good to find it. Oops, to find it, the information you might need. Yes, the fact sheets, and as I said, so they are published monthly. The newsletter, which is published twice a week electronically, with all kind of information about upcoming events, news from the patent offices, and so on. Yes, and we have the training, so like today. But as well, we offer on web-based trainings. So if you look on the website, we have a schedule. For this year, we have just 1 or 2 lessons still in November, but it will start in next year again from January on. And so we have web-based seminars to a number of topics. You have these training catalogs at the entrance, and there are some more. So we developed 9 modules of topics like introduction to IP, IP management, technology transfer, and they are as well taught as web-based seminars. And from January on, we will broaden it a bit because we are going together with the European Patent Office, which have developed in a project further topics, and so we can broaden up it a bit more. And yes, webinars, we call it, is usually it's around about 60 minutes, plus minus 10 to 20, depending on the questions. And yeah, yes, they are free of charge as well. And yes, thank you very much for your attention. Any questions? Feel free. Yes?
You promote that you are giving professional legal advices. If the advice is wrong, who is responsible for it?
We have a disclaimer. We are not working as patent attorneys. So it's a professional advice, which means they are people. Professional means in this case that people have studied law. They have studied patent law. They are not just newcomers in this area. But we always have the disclaimer in things that we are not in the way of being a patent attorney, for example. No. It's the idea behind it is especially for SMEs or for people from research to get an easier access to the topic, because everybody knows attorneys are expensive, and sometimes it's just a simple question, or you don't know if it's a simple or bigger question. And so this is the possibility to get a first and easy access into the topic. If you're going to, in a deeper way, if you're going to file an application, the helpline is not someone who's writing a patent application for you. Then you need a patent attorney, and this will be told everyone. So this is a part of our disclaimer that we are not working as patent attorneys. I think we have it. Yeah. Any further questions from your side? Then I thank you for being here. Thank you for inviting the IPL Help Desk.